We are here on a final order establishing the parent-child relationship and also in suit affecting the parent-child relationship. First requested the court take judicial notice of the temporary order, which was signed by this court on September 9th of 2024.
So noted.
Thank you, Honor. The terms of the temporary order will remain the same. The only two issues before the court in this final would be the retroactive child support and the court costs. If I may read the terms of the temporary and then take testimony.
You may.
Thank you, Honor. So to remain the same in the final are these terms of the temporary, that parents are joint managing conservators of the two children before the court, and that mother is the conservator with exclusive right to determine their residence within Dallas or any surrounding county. There's a standard possession and access schedule. Mother to apply for and maintain government medical. Father to pay $250 a month in cash medical support beginning March 1st of 2025. Any additional healthcare expenses to be covered by the parents 50-50. Child support to remain at $1,332 beginning March 1st with a step down to $1,065. And that was the extent of the terms of the temporary order. If I may call Miss Jones.
You may.
Miss Jones, what is your full name?
Sherry Jones.
And did you hear the terms of the temporary order to be made final today?
Yes.
Do you understand those terms?
Yes.
Are you in agreement with those terms being made final?
Yes.
And as far as a retroactive or back child support, are you in agreement for the period of time we're looking at to begin September 1st of 2022?
Yes.
Do you understand that that period of time ends right before the temporary order began, so September 30th of 2024?
Yes.
So in those 25 months, had Mr. Adkins given you any cash?
Yes.
How much did he give you?
I probably could say around the part of 1,000.
Okay. And did he also give you Cash App payments?
Yes.
And how much did he give you in Cash App payments?
I really don't know. I sent it to my lawyer.
Did he provide you Zelle payments as well?
Yes.
Do you recall the amount of Zelle payments?
No, I don't.
In that 25 months, did he give you payments through Apple Pay?
Yes.
And through Cash App and Apple Pay, had you also given him some money? Was it a back and
Yes.
forth? Okay. So to the best of your recollection, was the Cash App payments, was that about the $2,711 that was previously mentioned in the breakout room? Okay. So you're suggesting a total credit towards any retroactive judgment of $3,711. Is that correct?
Yes.
Okay. But that calculation, that doesn't include any Zelle payments or anything like that. Is that right?
Yes.
So before any credit is given, do you understand that the state has calculated a retroactive judgment for those 25 months in the amount of $32,871?
Yes.
And do you understand that Mr. Atkins will be billed for court costs by the District Clerk of Dallas County?
Yes.
Are you in agreement with that?
Yes.
Your Honor, I pass the witness.
Counsel.
Thank you, Judge. Ms. Jones, with regards to the time of separation, you guys actually separated in April of 2022, is that correct?
Yes.
Okay, and you were only agreeing to a start date of September 1st in an effort to resolve this and move forward, correct?
Yes,
But without an agreement, you would ask that the date go back to April of 2022. Is that correct?
yes,
Okay, and with regards to any payments, does the $3,711 sound accurate to you of what you received in payments from Mr. Atkins?
yes.
And
Kind
do
of a
you,
ballpark. Yes,
okay, and do you recall those payments being anywhere from $5 or $10 to about $200 here and there, very random? Would you
yes,
recall that? Okay, and you
yes,
also gave money to him as well, is that correct?
yes,
And with regards to the time frame of separation, these payments that Mr. Atkins is asking for credit for go back to March and April of 2022. Is that correct?
yes,
So he's asking for credit for payments back that far. And you would ask that the retroactive go back that far, correct?
right.
Okay, and you're happy to give him credit for any payments that you've received. You believe that amount to be about $3,711. Is that correct?
Yes.
Okay. And you guys don't have any issues with the schedule, is that correct?
What schedule?
Your possession schedule with your children?
Um, let's have that. Can we have that in black and white?
Well, yeah, you will. You will have an order. You will have a final
Okay.
order after this.
Okay.
Okay. And isn't it true that your dad helped Mr. Atkins obtain employment at his current employer? Is that correct?
Yes,
And they actually work at the same place. Is that correct?
yes,
Okay. And so you're in agreement with the terms of the temporary order with regards to current temporary support and medical support.
yes,
And in the future, would you like Mr. Atkins to add your two children on his private insurance that he has through his employer that he got through your father?
yes,
Okay, and that you believe that that would be in the children's best interest and everybody's best interest, even the state's, for those kids to be on a private health insurance in the future that Mr. Atkins has available to him through his employer. Is that correct?
yes,
And that's a pretty good policy. Would you agree?
yes.
Okay, I'm gonna pass the witness at this time, Your Honor.
Any further questions of this witness, Ms. Sweet?
Yes, Your Honor. So when in April, do you remember the day that y'all had stopped living together, that you're separated?
No, I don't know the exact date.
Do you know whether or not during that period, Mr. Atkins was employed?
Um, I think he started working like the end of 2022.
And from April of 2022 up until the end of August of 2022, had he given you any cash?
Yes, he has gave me cash. As I stated before, 1,000. I can probably think of in my head.
Okay, so it's still just the $1,000 that he'd given you since
Yes,
2022.
you said in cash.
Yes, in cash. That's correct.
Yes.
Your Honor, I pass the witness.
Any further questions?
Just one clarifying question. With regards to, well, let me say this, let me ask this. You have a printout of cash out payments from Mr. Atkins, is that correct?
Yes.
Okay, and you're in agreement with that amount, which was approximately
Yes.
2,000. And with regards to any other payments, would you estimate that total amount to be about $1,000, whether it was Zelle or cash in your hand or whatever the case?
Yes.
And are you asking this court to affirm arrearage that the OAG has calculated using their calculator and as well as information that they have available to them that you may not have available to you?
Yes.
And are you asking them to credit Mr. Atkins in the amount of $3,711 as part of their calculation?
Yes.
And whatever the balance of that, are you asking the court to affirm that as retroactive child support and make the terms of the temporary order a final order so that you and your kids can move forward?
Yes,
And are you also asking that those retroactive payments be made in monthly payments of approximately $200 as also suggested by the OAG?
yes,
Okay. And for now, you're okay with the government insurance, but again, your goal would be for them to be on private insurance. That is a good policy that he has through his employer.
yes.
Okay, I'm gonna pass the witness.
Any further questions, Ms. Sweet?
Not of this witness, Your Honor.
What is the current child support?
The current child support amount, Your Honor, is, apologize one moment. It is $1,332.
A month.
Yes, Your Honor.
And how was the retro calculated?
Your Honor, I apologize. So then I would like to offer in evidence what's been marked for identification purposes as State's Exhibit A. That's a retroactive calculation sheet. And
No
that's showing
objection.
how I did it.
No objection, Your Honor, to that.
Well, I can't see it, so you're gonna share it with me on the screen?
Yes, Your Honor. May I share my
Okay.
screen?
Yes.
Okay, let me get that. Oh, sorry, Your Honor. It's been a while. Okay. Your Honor, can you see my screen?
I can.
Excellent.
I can see it.
Your Honor, so for the 25 months, 4 months was at $984, 12 months at this rate, and 9 months at this rate based on income information made available to the state. And the subtotal before any credit is $32,871.
Okay. And so there was some testimony about him not being employed for a period of time. Or did I just mishear that?
Yes, Your Honor. If the state needs to recalculate, so this is from the September 2022 up until September of 2024, the state would need to recalculate if the court believes that using April of 2022 till
Okay.
September of 2024 is appropriate. And that was the period of time from April 2022 to September 22, where Mr. Atkins was likely unemployed, excuse me, for the majority of those months.
Okay. All right. Thank you, Ms. Sweet. I just needed to know that. Thank you so much.
Yes, Your Honor.
You can stop sharing. Okay, thank you. You may call your next witness.
Yes, Your Honor, if I may call Mr. Atkins.
Mhm.
Yes.
Mr. Atkins, what is your full name?
Raymond Kevin Kenneth Atkins Jr.
And do you recall the terms of the temporary order regarding conservatorship, visits, and current support?
Yes, I remember.
Are you in agreement with those terms remaining the same as in the final order?
Can you explain the final order and
Sure. Are you in agreement to continuing to be joint managing conservators with Ms. Jones moving forward?
Yes,
And are you in agreement with Ms. Jones having the exclusive right to determine your children's residence within Dallas or surrounding counties?
yes.
Are you in agreement with the standard possession and access schedule?
Um, right now the schedule that we have is we get the kids whenever, but I would like to start that first, third, and fifth, whatever they do.
So do you understand that as long as you and Ms. Jones can come to agreement in advance, you can do any schedule that you can come up with, but in the absence of agreement, you would have your children first, third, fifth, weekends of the month, Thursdays and alternating holidays, as well as an extended period in the summer.
Yes.
So you're in agreement with that?
I would like to do the last part. You said first, third, Thursdays, got half holidays, whatever.
Mr. Atkins,
Yes.
the standard visitation schedule will be attached to your order. Absent any agreement between you and Ms. Jones, that's what you're gonna follow. So if you guys have been doing something else and you don't agree to that anymore, then you follow the schedule.
I agree.
Okay?
Yes.
All right. You may continue, Ms. Sweet.
Mr. Atkins, do you have private health insurance available for your children through your employer?
Yes.
Do you know what the cost of that would be per month just for your children?
Um, For me and my children, it'd probably be like $200 or something like that. Somewhere around there.
Um, for the terms of the final, are you wanting to have Ms. Jones continue to carry your children on a government plan, or are you wanting to put them on your private plan and have the order, order you to do so?
So that's why I was trying to do that first, but they said that we could take care of that later. So I can't put them on my insurance till November of this year.
And why is that?
Because that's the only time I could add somebody to my insurance. Only,
Is that your open enrollment period?
yes, ma'am. So I already missed.
Do you understand if there was an order that required you to put your children on a private health insurance, that then it would act like open enrollment for your employer and they would put your children on it?
No, ma'am.
So would you want the final order to have you carrying the private insurance through your employer?
Yes.
Do you understand that if you're not correct about the cost, that you're still going to have to put your children on the private plan, even if it's more than what the state was previously asking for as far as cash medical support?
That's fine. It's my children. I could do that.
Okay, so it's $200 a month, you believe, for all three of you?
Yes.
So would it be a fair statement to say that just for your children, then it'd be about $133.33?
Give or take, yes.
Would that health plan include dental, or would that be a separate cost?
We include dental, medical, and if I want to add vision, that'd be extra.
But that $200 that covers health and dental?
I believe so. I'm not sure. I'm just giving you a roughly number right now.
So as far as the terms of the final, would you just want it to have you carry a private health insurance, as you don't know if the dental is included?
Yes, ma'am.
And has your income changed at all since September of 2024?
No, ma'am.
So do you understand that based on that change from the temporary order, that your child support would increase a little bit?
Yes.
So instead of the 1,332 moving forward, your child support would be 1,365.
All right.
Are you in agreement with that?
Yes.
Miss Sweet, what is the cash medical right now?
$250, Your Honor.
Okay.
And then Mr. Atkins, do you understand that the amount of child support you pay would reduce when one of your children turns 18 or graduates high school?
Yes.
And that amount would be $1,092 based on your current income. Do you understand that?
Yes.
Okay. Are you in agreement with that?
Yes, ma'am. I do have one question. Well,
Hold on
no.
one moment. The court will likely give time at the end for any questions.
Yeah.
But do you understand any additional healthcare expenses that aren't covered by your insurance will be covered by you and Ms. Jones 50/50?
Yes.
You also understand that if you fail to carry health insurance, you may be liable for 100% of the costs of any care that y'all have to pay for.
Yes.
Do you understand that you'll be billed for court costs by the district clerk of Dallas County?
Yes.
Do you disagree with that?
No.
Regarding the retroactive or back child support, when do you believe that you and Miss Jones separated or stopped living together?
I know it wasn't all the way back in 22, but when we was in court last time, they was just trying to go back 18 months. And that 18 months or so, it added up to 26,000. So that's why it just hit me for 32,000 and change. Because they were trying to go for 26, but now it's 32. and they was on.
So do you understand that everything has been recalculated? So we're using the numbers as I've calculated them today, but I'm just asking you about a time period. So, do you remember the month and year that you and Miss Jones separated?
I would say back in 2023, I give it, I don't know, probably May.
So you don't believe that you separated in 2022, you believe it was 2023?
Because like she said, we were still living together when once I started working at my job, and I started the job with her father back in August of 2022. We were still together then, so I don't know how it went back that far. That's why we didn't stop living together until 2023. And I can't really say the month, but I will say around March, April, May, somewhere around there.
So do you understand that the state's calculation is based on 25 months? It's from September of 2022 up until September of 2024.
Yes.
But you believe it should be less time frame. So the time frame should actually be from March or April of 2023 till September of 2024. Is that correct?
Yes.
Okay. And in that time, had you provided Miss Jones any cash?
Yes.
And just, cold hard physical cash, how much had you given her in that time frame?
I don't know. I would say more than $3,000, $4,000.
Miss Sweet,
Yes, Your Honor.
I think we lost Miss Jones.
Judge, my client has been on this call since 8 a.m. and she had to go back to work. I told her that if she was needed for testimony, that I would try to text her back. She works in a hospital and she was on the phone since 8 a.m. and her job said that she had to go back to work.
Okay. Go ahead, Miss Sweet.
Thank you, Your Honor. Mr. Atkins, had you also provided Miss Jones payments through Cash App?
Yes.
Had you also provided her Apple Pay payments?
Yes.
Had you also provided her Zelle payments?
Yes.
And you provided our office with copies of some screenshots of those payments. Is that correct?
Yes.
Your Honor, if I may screen share.
Yes.
Mr. Atkins, can you see my screen?
Yes.
Now looking at these, what are these payments?
Anytime she asks for money or need, she'll call me and I send it. Either way, Cash App through Zelle or Apple Pay.
So regarding what's showing on the screen though, where are those payments from?
Oh, this is from Apple Pay.
Okay. And and they are to Miss Jones, is that correct?
Yes.
Okay. Your Honor, our offer and evidence what's been marked as State's Exhibit B.
Any objections, counsel?
No objection, Your Honor. Well, I will make the objection. I did send discovery to Mr. Atkins so that I could have all of this information just in case the two parties disagreed. And the discovery was due by January 5th, and it was not provided to me. But for the sake of trying to resolve this once and for all today, I will not object to the exhibits being presented to the court.
State's Exhibit B is admitted.
Your Honor. So Mr. Atkins, do you understand that I've looked at all 9 pages and done calculations on exactly how much you'd given Miss Jones minus how much she had paid you for the periods from September of 2022 until September of 2024?
Mm-hmm.
I'm sorry, is that a yes, Mr. Atkins?
Oh, yes. Sorry. Yes.
Okay. So do you understand that that total of debits minus the credits provided by Miss Jones to you, that my calculation yielded $1,162 for Apple Pay payments?
Okay.
Are you in agreement with that, the time periods as well as, or let me rephrase, do you understand that I did limit it by time periods and I did reduce the amount provided to Ms. Jones by the amount that she provided to you during
Yeah,
those time periods?
I understand.
Okay. Okay, so Mr. Atkins, I'm showing you now it's marked as State's Exhibit C. Can you see that?
Yes.
Okay. And what is this document?
This is the Zelles from my bank account, Navy Federal.
So, but this is are these
Tr-
bank statements
Yeah,
from
yeah, bank
Navy
statement.
Federal?
Yeah, bank statements.
And through this bank, had you provided Zelle and some of the Cash App payments you had made to Miss Jones?
Yes, ma'am.
Okay. And do you understand that the state has gone through this document as well, marking any debits, which are payments to Miss Jones and Miss Jones only?
Yes.
Do you also understand that this is limited by the amount of time from September 2022 until September of 2024?
Yes.
Okay. Your Honor, I offer no evidence what's been marked for identification purposes as State's Exhibit C, excuse me.
No objection, Your Honor.
State's Exhibit C is admitted.
So, Mr. Atkins, do you understand that after totaling the amount of debits paid to Miss Jones and Miss Jones only from all of the bank statements you provided for 2022, 2023, and 2024 in this document, that I've calculated that as $9,717.58, 58 cents in Zelle and Cash App payments?
Yes.
Oh, apologize. I didn't mean to stop sharing. Mr. Atkins, can you see what I've marked as State's Exhibit D?
Yes, that's Cash App.
Okay, and so these are these payments made to Miss Jones as well?
Yes.
And is she denoted by the icon right here in red?
Mm-hmm. Yes, ma'am.
Is this your profile?
Yes.
So do you understand that the state has looked through this document as well?
Yes.
And do you understand that any payments that also showed up in your bank statements, that I did not include those in calculating the total amount that you'd provided Miss Jones?
Yes, ma'am.
So there were no duplicates in the state's calculation. Do you understand that?
I understand.
Do you also understand that I had also limited this document to the periods of time from September 2022 until September 2024?
Yes.
And do you also understand that I've not included, or I've subtracted the amounts from this document that Ms. Jones had provided to you?
Yes.
Your Honor, I offer in evidence what's been marked as State's Exhibit D.
Stacy, any objection, counsel? Counsel, you're muted.
Ah, I'm sorry, Your Honor. I didn't realize that. No objection, Your Honor.
Okay, State's Exhibit D is admitted.
Thank you. So Mr. Atkins, do you understand that the total I came up with when looking at these additional Cash App payments that weren't reflected on Navy Federal, that the amount was $2,758.82?
Yes.
And is that because your Cash App is connected to more than one bank account?
Yes, ma'am. So I couldn't pull up my other bank account because I don't have it no more. So it's still more money that I owe Sherry, but I'm not worrying about it. I mean, I couldn't pull it up, so it is what it is.
And are you also requesting that you get credit for $3,000 to $4,000 in cash that you provided, as well as all the payments from Zelle and Cash App and Apple Pay?
Yes. Yes, ma'am.
So if credit were to be $3,000, do you understand that the total credit you're requesting is $16,638.40?
Yes.
Okay. Do you understand that based on the state's calculation from the period of September 22 till September 2024, the total after the credit you're requesting would still be
somewhere 16,000.
I apologize, one moment. Would still be 27,000, or excuse me, $16,232.60.
Yes. Also, if it changes, if they change the months, not all the way back to 2022, because like I said, we were still living together.
Okay.
Judge,
So,
I would object to that. My client testified that they were separated in April of 2022. Not only that, but these same payments that he's wanting credit for go back past that. So to me, that is evidence of the fact that they obviously weren't together. So you want payments for that time, but you're saying you weren't together. Also, my client testified that he gave her about $1,000 in cash. And so I would object to the state using the 4,000 or 3,000 that Mr. Atkins is claiming today.
Okay.
In April, I didn't go back to April, but okay.
Mr. Atkins, that's fine. She's made her objections. Objection noted, counsel.
Thank you, Judge.
Ms. Sweet, you may continue.
thank you. Mr. Atkins, if the retroactive or back child support judgment, are you in agreement to that being 18,000, or excuse me, $16,232.60, or do you still believe it should be a different amount?
It still should be a different amount.
Okay, what amount do you believe that the judgment should be?
I really don't know. To me, I just don't think it's that high. It should have been that high. Like I said, because I've been there with them, and like I said, we were still living together. And if you go back to my statements, I want to go back all the way to January, February, March, April, May, June, July, August, September, back to August in my statements. If you go back to Zelle, the first statements you see, it would be August 23rd or 22. I then went back to April. That's I think
Can you
exhibit.
explain to the court why the payments that you'd submitted to the state, proof of payments and all that stuff, so they appear to have started in February of 2022. Can you explain
Correct.
that?
What is that off of Navy Federal?
For the Cash App payments, the screenshots that you had sent to the state, these payments began, it looks like February 2022. Can you explain that?
What I did was I sent everything in my phone. I didn't delete nothing or whatever. I just sent from whenever I started my transactions with Sherry all the way to 2024. I still didn't show everything I've done after 2024 or before that, but I started from 2022, whenever the transaction started, to then. I've been always giving her money when we was living together or when we wasn't living together. I'm just proving that I always gave her money. That's why I sent you everything.
So do you understand that if the court reduces the time frame that we're looking at, that you're not going to get credit for amounts provided outside of that time frame?
Yes.
Is there anything else that you would like the court to know regarding the retroactive child support judgment?
All right, no, man. Just want to get this over with by now.
Your Honor, I passed the witness.
Okay, what is the base amount before we give him any credit?
May I share my screen, Your Honor? It might help to see State's Exhibit A.
If you just
Possibly.
tell me, I'll be all right.
Yes, Your Honor. I understand. $32,871. 32,871.
Judge, just one other thing. Similar to the way that in the Cash App statements, it shows payments from my client to Mr. Atkins, and in the Apple Pay, it shows. Sorry, Judge. And
I'm
is my
listening.
PO? Oh, okay.
Yeah, I
I
can
thought
hear
my
you.
PO was off. I'm sorry.
No, I can hear you. Go
So
ahead.
similar to the way that there are Cash App payments from my client to Mr. Atkins, from Cash App and Apple Pay, there are also payments from my client to Mr. Atkins for Zelle. Those are not shown. Miss Sweet only took into account payments from him to her. So the same way that we accounted for payments from her to him, that number would be decreased. In other words, she also Zelled him money as well, and that was not taken off.
But it wasn't counted. He was not given credit for it.
Oh, well, Miss.
So
Miss
it
Sweet
doesn't
said that-
matter because she didn't give him credit for the payments.
Okay, well, if she didn't
She
give him credit, then
separated
that's fine.
those out. She didn't
Okay,
give
if
him
she-
credit for those.
Okay, if she didn't give him credit for it, then that's fine. I thought she
Okay.
had given him credit, and that's
No.
why it went down to 16. Okay.
No, that's why she told me that she didn't give him credit for it.
Okay, thank you, Judge, for that clarification.
Anything else, Miss Sweet?
No, Your Honor, other than the
Anything?
state's recommendation.
Okay, what's your recommendation? I'm sorry, go ahead.
Your Honor, the state's recommendation is from the retroactive calculation sheet submitted to the court. Apologize, give me one moment. I had made changes on it. The state's recommending the credit be $14,638.40. And that the total retroactive judgment be $18,232.60. That's the Zelle payments, cash, and Apple Pay for the credit, plus the $1,000 in cash, Your Honor. And then the state is requesting that that be paid back at a rate of $142 per month, beginning March 1st.
And Judge, I would ask that that retroactive payment be $27,000, taking into account the information that I have available to me, because I did send discovery so that my information could be accurate. And again, she did give him credit for those Zelle payments, and those Zelle payments did not account for what she paid to him. And so I would ask that the retroactive be $27,000.
Okay, so she gave him credit for the payments that he sent her.
Mhm.
She did not give him credit for the payments that she sent him. That doesn't make sense to me. We're just
So-
giving him credit for what he sent her.
Right, Judge, but what I'm saying to you is, for example, in Cash App.
I
they
don't know
both-
why she sent him those payments. She could have owed him money. I don't know.
So we're assuming that all of his payments were for child support, but we're
I'm-
not assuming her payments. We're
I'm
assuming her
gonna
payments.
assume
Yeah.
that she gave him money and he gave her money because they were in a relationship. That's what I'm assuming.
Okay.
Okay,
It
that's
seems
all
like
I'm
he's getting credit
assuming.
for every single dime that he gave, and it wasn't all child support. But my
Okay.
client's not getting that same credit.
Okay.
So, okay,
right.
thank you, Judge.
So I will make this a final order. The terms of the temp order will be made final except for the health insurance. Health insurance, dad is to carry private health insurance through his employer, which is going to, but his child support is going to remain $1,332 a month. Am I correct in that, Miss Sweet?
Yes, Your Honor, that was the amount from the temporary order.
That gives him credit for the $250 a month that he was given credit for the health insurance. We don't have an exact amount, so we're just gonna leave it at $250. Court costs will be billed to Mr. Atkins. I will give him credit for $15,138.40 toward the judgment. And the final judgment will be $17,732.60. Are there any questions?
Yes, just to clarify, once my children is back, and once my children is on my insurance, that $250 will come off.
The $250 is, you're not gonna be ordered to pay cash medical. I'm just giving you credit towards your child support of $250.
I got you.
Okay?
Yes, ma'am.
Anything further? Any other questions?
No, ma'am.
Okay. There are no further questions. That's my ruling. If you don't like it, if you think it's not fair, Mr. Atkins, you have 3 days to appeal, 30 days to file a motion for new trial. Anything else, Ms. Sweet?
Yes, Your Honor, I apologize. I missed the repayment of the $17,000 judgment.
What did you set it at, ma'am?
Your Honor, if it's going to be that amount, I believe 139 would be appropriate, or we could just do an even 140.
Even 140 is good.
Thank you, Your Honor.
Thank
Nothing
you.
further from.
Dismiss, Your Honor.
Yes, you are. Thank you so
Thank
much.
you.
Uh-huh.